Good morning. We are here today to talk about bankruptcy. My name is Brandy Austin, and we are from the Brandy Austin Law Firm. This is Seth Crosland. He is we call him business, bankruptcy, and criminal. And January was Family Law Month, and so we're going to talk about bankruptcy during February. Bankruptcy is a scary process. People don't understand it. They think, okay, it just gets rid of all your bills, but you have this black scar on your credit forever. So we're going to clear up some rumors and talk a little bit about the process so that people are more comfortable with it. And all of our consultations are free, so if you have any questions at all, if you just want to see if you qualify for bankruptcy, then come on in, give us a call, 817-841-9906. And we'll get you a free consultation. We'll go through everything and let you know if you qualify. All right, Seth. So I'm going to be a person that comes in with some questions, and you're going to tell me about the process.
Absolutely.
Okay. So, for example, I have a credit card bills. $35,000 in credit card bills. I have a mortgage on my house. I have a $125,000 mortgage remaining on my $150,000 house. I have a car. $40,000 car, $32,000 left on it, and I have some medical bills, say $10,000 in medical bills, and I only make $35,000 a year. So obviously, I was able to afford the mortgage and the house, but the medical bills and the credit card bills have kind of run me over.
Sure.
What are my options?
Well, first of all, you're not alone. Most Americans, I think the last stat I read about the average credit card debt for an American is about $20,000. So you are not alone in this process. What we need to do is, your income is perfect. You'll qualify for a Chapter 7 bankruptcy. Chapter 7 bankruptcy is the most common bankruptcy that we file. We call it a liquidation. What it's going to do is it's going to get rid of all of your unsecured debts, all of those credit card bills, all of those medical bills, payday loans, anything that's not secured by some property is going to be discharged. And when a client or a potential client comes in, I try to tell them that it's actually not a scary process. It's a very simple process. There are very few things that the client is actually going to have to do. They're going to have to take 2 classes, a credit counseling class and a debtor education class, and they're going to have to go to one meeting. A meeting of creditors, and that meeting is 5 to 10 minutes long. So, and that's all they're going to have to do. I'll do the rest. So, I try to put their mind at ease, tell them this is really actually a very simple process for you. And at the end of the day, you're going to be in a far better position financially than you are right now.
So the debtor education class, you can actually take that online.
Absolutely,
right?
You can take both classes online. They take about an hour each. They're honestly pretty silly. First one is really silly, but the second one actually can teach you some financial management skills that you may or may not know.
So, and we want people to manage their financials better, so in the future, they don't have to file again, correct?
Absolutely.
Because there's a limit on how many times or how often you can file.
You can file Chapter 7 bankruptcy every 8 years. Chapter 13 is different, but yeah, Chapter 7 is every 8 years.
So tune in next week for Chapter 7 to Chapter 13, and we'll talk a little bit more about that. Okay, so what about student loans? Because a lot of us, myself included, have student loan debt, and it's, it just sits there and sits there and sits there. What can we do?
Generally speaking, student loan debt is not dischargeable. I say generally speaking, there are exceptions. I'm not going to go into the process of having a student loan discharge. It's complicated. Most people don't qualify. The courts are getting a little bit more lenient on student loans and getting the student loans discharged, but as of now, you basically have to not be able to work for the rest of your life or do what you were doing, what you went to school to do. So it's very difficult. So you're still going to owe the student loans. That is the one thing that is a non-secured debt that isn't discharged to bankruptcy.
Okay, but there are options, especially with federal loans, changing the payment amounts.
Oh, yeah, sure.
So even if you are scared of bankruptcy, there are still alternatives for rearranging your
Sure.
debt.
Absolutely, especially with the federal loans, you need to look at there are probably 7 or 8 different ways you can pay as you go, income-based payment plans, those kind of things. You definitely need to look into all those.
So there are a lot of companies out there who say, well, we'll reduce your student loan debt. Basically what they're doing is just taking your income and applying for that the program that allows you to change your payment, correct?
Right.
And
yes.
is that something that anyone can do on their own?
Anyone can do it.
So you don't have to pay or give money or do anything
Right.
to a student loan company. Just call, I think there's probably a number they can call, right?
You can go online to, I can't remember the website.
We'll put it in the comments.
Right, you can go online to the federal student loan website, and or you can go to your servicer, and it'll say, it'll direct you to that link. If a lot of people have Nelnet or Navient is a big one too. You can go to the website and they'll direct you to where you need to go.
So if student loans are all that you have that's causing the problems, go to those websites and rearrange that debt on your own. Don't come for a Chapter 7 bankruptcy. You don't need to call a company and pay any money for it. Just go and take care of it yourself. It's an application. It's not difficult.
Yeah, it's not difficult. And you'll just need your tax returns for the last year, I believe, and maybe some pay stubs. It's very simple. And I want to say, I did it myself. I don't know, you can consolidate your student loans and get a lower interest rate and get a lower payment too. You want to look into that if you have private loans as well.
Okay, so let's talk a little bit about tax debt. What can you do with tax debt in bankruptcy?
Well, in the Chapter 7, again, it's a little bit more difficult. Some tax debt is dischargeable as long as, again, there's a 3-step rule to determining whether taxes are dischargeable. It has to have been owed more than 3 years. I don't remember all of I have to look it up, but I can put that in the comments. But generally speaking, if you owe tax debt from, say, last year, it's not going to be dischargeable. But if you have tax debt from 2010 and you filed your taxes on time, that tax debt can be discharged. Next week we'll talk about a Chapter 13 and how to deal with taxes in that, and it's a little bit easier. But in a Chapter 7, like I said, if you had a tax debt from last year, you're probably still going to have to pay that.
Okay.
But the IRS will work with you. I mean, they're actually one of the better creditors to work with. They're surprisingly easy to work with.
And they don't want to put you in jail.
No, they don't want to you can't pay if you're in jail. So
Kind of like child support.
Right.
Which you also cannot get rid of.
Can't get rid of child support. You can't get rid of any debts, any criminal fines, any debt that was incurred because of a personal injury due to
Gross negligence.
DWIs, or in gross negligence maybe. But anything criminally related, generally speaking, you're not going to be able to discharge that too.
Okay. But if credit card debt, what about loans secured by furniture?
Okay. This is one of my biggest pet peeves. And a big one is, what's that company? Cons.
Yeah.
They claim to have what's called a purchase money security interest. They've never been able to prove to me that they have. And they will come to the meeting of creditors, the only creditor that ever does, and want you to sign a reaffirmation agreement. And a reaffirmation agreement basically means you agree to remain personally liable on the debt in order to keep the thing, whatever it is. My argument is, if you want a 4-year-old couch, you want to come repossess it, come get it. You're not going to sell it. So they never do. So I never recommend a reaffirmation agreement for Cons or Aaron's or one of those companies like that.
But that's not actually the case when it comes to Best Buy credit cards and recent purchases of computers, iPads, and electronics, correct?
You have to be careful about items you purchase within, say, 90 days of your bankruptcy. An argument can be made that could be a fraud. There's some fraud involved in there. But again, Best Buy. I've fought with Best Buy too, and they've really stopped doing it. But they used to try to claim a purchase money security interest in property that bought on the credit card. But going back to law school, a purchase money security interest has to be specific to what the product is, and it can't just be a blanket credit card, or Citibank can have purchase money security interest. So they never win that argument. They've kind of stopped trying. But yeah, if you purchase anything within 90 days, a big item purchase, a car, something like that, and then you try, well, maybe not a car because it's secured by, it's secured, but a big money item, and then you try to discharge that, you're going to have some problems probably.
Okay. And so people will come and they'll talk to you, and you can go through the means test. Now, the means test is what we use to qualify people to file Chapter 7 bankruptcy, right? So you take all this information. So there's a list of documents that are helpful when you come in for bankruptcy, and we offer means tests at a really reduced rate, and it gets applied towards your bankruptcy. If you do file bankruptcy, if we can do something else for you, or if you don't qualify, or if there's something else, we can negotiate debt sometimes. We can apply the charge for the means test to the negotiation for the debt. But we always, come on in. We can do the means test. There's a program that we run it through, forms that we, fill out and stuff. So we happily do that for anybody in consultations.
And I can generally tell you if you qualify or not.
It does get a little hairy.
Yeah, there can be some
cars, multiple
if
houses.
If your income is, if you make $80,000 to $90,000 and you have no kids, it's a little bit more complicated. I have to do a little bit more creative math to get you into a 7, but it's all about math, and generally we can make it work for you. One way or the other will help you out for sure.
Absolutely. So basically, people come in, we go through the means test, they get qualified, and then there's paperwork, right?
It's paperwork.
A lot of paperwork.
I have an intake package that I have you fill out. Basically, I need all your assets that you have, all your cars, your furniture, your socks and shoes. I don't need to know exactly how many socks you have, but I need to know if, you have children's furniture, that kind of stuff. And we'll list it. We'll have to list everything in the petition. You won't lose anything. It'll be all exempt, but I need to know what you have. You can't hide any assets. If we don't list something and the trustee finds out later, there could be an issue. We can always amend and add stuff, but the trustee really looks hard at those things, and it's kind of like school. You don't want the principal looking at you too hard. You want to just do things the right way. When we prepare your bankruptcy, we'll pull your credit report, and it'll have most everything all debts you owe. There may not be some things on there like credit card bills, payday loans, things like that may not be on there. So if you have that documentation, you'll need to get that to us.
This isn't a regular credit report, right? This is a special credit. This isn't like TransUnion or any of those. This is a special credit report that pulls everything that even you may not know that you have out there. Medical, all the stuff is going to be on this report.
It's pretty comprehensive. Sometimes, but things slip through the cracks. A good thing to know, though, also is if, for whatever reason, when we file and we miss a debt, it happens. It happens with medical bills. It happens, sometimes you'll get a bill from a dentist that you didn't know about. Any unsecured debt you owed prior to the date of filing is going to be discharged, whether it's listed or not, as long as you didn't intentionally leave it off. Now, if they want to try to prove you intentionally left it off, it's going to be tough. But it's most debts, even if you forget to list the debt, it's going to be discharged.
Okay. So you have your paperwork packet that you fill out. You take your first financial course, and then we file it with federal court. It's always filed in federal court because bankruptcy is a federal, privilege for Americans and citizens to discharge their debts. And then we wait a certain amount of time, and there's a meeting of the creditors.
Right. Once you file, a person called the trustee is going to be appointed. The trustee basically acts as a referee between you and the creditors, and it's his or her job to determine if you have any assets that they can take to sell to pay some of the creditors. In a typical bankruptcy case where you have your house, your furniture, your dog, you're not going to have any non-exempt assets. So your case is going to be what's called a no asset case. Once that trustee is appointed, we'll have probably 3 weeks to 4 weeks, depending on the docket. 3 to 4 weeks later, we'll have a meeting of creditors. And that meeting of creditors, it's kind of a misnomer. Other than cons, no creditors ever show up to this thing.
But they can.
They can, but they very rarely do. So don't be nervous, I guess is why I always tell, don't be nervous. It's going to be okay. And the meeting is pretty quick. It's 5 to 10 minutes. Depending on the district you're in, either I'll ask you some questions or the trustee will ask the questions, and then that's it.
We have the questions ahead of time, so we'll go through them, and based on the information you've given us, we'll tell you if you need to speak up about anything in particular.
Right. And it's very simple questions. Did you have a chance to review the paperwork before you signed it? Was everything true? That kind of thing. Is there anything you need to change? Were all your assets listed? Were all your debts listed? It's very simple. You'll know, and we'll go over it ahead of time. You'll know what to expect.
And the number one thing in bankruptcy, complete honesty. Just be
Always
honest.
tell the truth.
And just be honest.
Yeah.
We can fix it more if you're honest about it up front than if you hide it from us
Right.
or the trustee.
Absolutely.
So after the meeting of the creditors, then you have to take another course.
Yes.
The helpful one.
Once you file, you have to take the debtor education course or financial management. It can be taken any time. You don't necessarily have to wait till after the meeting of creditors, but it can be taken any time after you file. It just has to be filed. It has to be taken, and I have to file the certificates prior to the 60 days after the meeting of creditors. If it doesn't get filed, your case is going to be closed. It's going to be closed without a discharge. You're going to have to pay another $250 to reopen your case just to file a piece of paper, and you don't want to do that. And I'll remind you several times to take the class and get it done, and it'll be no problem.
So there are also a lot of, so let me go back. After you complete the course, your meeting of the creditors, then you get your discharge, and your debts are discharged.
Done.
So, and that's it. It's not a difficult process.
Yeah.
So there are a lot of firms that are high volume bankruptcy firms that maybe, we don't have a large fee, but they charge sometimes next to nothing to do these. But the problem is they miss stuff, and they don't give you the personal attention. They don't walk you through the process. Could you speak a little more about that?
Sure. Generally, you see these big law firms, but these bankruptcy firms that handle a lot of high volume. The paperwork's not going to be prepared by an attorney. It's going to be prepared by a paralegal, which is fine. I'm sure they do great work, but they're not going to know all the ins and outs that I'm going to know or any of our bankruptcy attorneys are going to know. And there are tricks to the trade in getting everything right, and we pride ourselves on getting everything right the first time, so your case goes quickly and smoothly, and you have less to worry about.
So we offer a program for our clients, an online program that allows them to check on the process of their case at any time. They can log in, they can look at what's going on, what's been filed, what hasn't been filed. They can upload documents, they can message the attorneys, they can message whoever they want that works in the firm. They could add things to the calendar if they want to request a date or a task or anything like that. All this information is right at the fingertips of our clients. We really try to break down the barriers between us and the clients and focus on your needs if you're a client. And we really want you to use everything available and ask us questions and let us help you through this process. It can be scary, but we're there for you. We're there to help you through the process. So next week we'll talk about Chapter 7 and Chapter 13. We'll go over a little bit about filing married or separate, single, divorce, married, filing bankruptcy after divorce. Maybe we'll do a whole episode on that.
That might be a good idea.
Those questions actually come up a lot once you get divorced. There's a lot of debt to split because it is a community property state, and so debt is property kind of. So We'll put Seth's contact information in the comments along with the websites that we talked about. Again, we offer free consultations. Our number is 817-841-9906. If you want to email, you can email Seth, S-E-T-H, at Brandy, as in the wine, Austin as in the city, law as in what we're doing, .com. And he'll be happy to get back to you or just give us a call. Thanks, and I hope you guys have a great day.
Thank you.